Let's go live now to Melbourne. Father Frank Brennan joins us. Father Frank, thanks for your time. You heard what the Prime Minister said in response to my question based on your book and proposed amendment. He references the former High Court Judge Robert French in defending his proposed form of words. What did you make of his answer?
Well, I respect the Prime Minister, of course, in putting forward this argument, and Robert French did indeed write a good article there in the Financial Review, but it was his article that actually highlighted the problem, Kieran. He made the point that if there could be representations made by the Voice not only to Parliament and not only to ministers but also to public servants, that if need be, if there are unintended consequences, if that was done by Act of Parliament, then Parliament could fix it up. Well, this is precisely the problem, Kieran. If you put it in the Constitution that there's a constitutional entitlement for a constitutional entity to make representations to public servants, there's no way Parliament can fix it up. It's there forever. So I think he has nicely highlighted the issue. The other issue which he's highlighted nicely is that indeed he does have a group of constitutional experts who are meeting confidentially, and he has a group of Indigenous leaders who are meeting confidentially. Now, this is a very novel way to try and amend the Australian Constitution. We Australians are great egalitarians, and our Constitution is a very democratic instrument in the sense that it can only be amended by an overwhelming majority of the people, that is, a majority of voters in at least 4 of the 6 states. Usually the way we go about trying to amend the Australian Constitution is by having some sort of people's convention where people can have their say, or having a parliamentary committee process set up where anybody and everyone can have their say, but where then all of our elected leaders contribute and where you get the competent advice of people like the Solicitor General. Now, to date, what we've had is the Prime Minister in July last year announced a captain's pick set of words, and yes, Robert French said they looked okay to him. But what we had was this confidential constitutional panel. Before Christmas, they were trying to assure us, look, there's absolutely nothing to see here, no problem, and we're unanimous. Well, we now know they're not unanimous, and we now know that they, some at least, do concede that there are problems. And we've had 3 retired High Court judges.
Yeah. No, I was sorry to interrupt, but I was just going to say, do you think the Prime Minister is open to some of the critiques from what he said today? Do you think he's open to change?
Well, from what he said today, I think he is. The problem that confronts him and all of us in terms of process, Kieran, is that he's told us he's going to bring in a piece of legislation which is going to contain the captain's pick set of words, and we can all have our say about it. Well, it would be far more sensible, of course, to set up a parliamentary inquiry and to hear from anybody and everybody, as Dean Parkin was saying, and then look at an appropriate set of words. But I was heartened by him today. I think that in response to you, he showed an increased openness to having those words closely scrutinised. And I think once they're subject to proper scrutiny and proper legal analysis, people will see that what's essential is to get back to basics, where the Referendum Council in 2017, which included very distinguished Australians like Noel Pearson and Murray Gleeson, the retired Chief Justice of Australia, spoke in their recommendation of a voice to Parliament full stop, not a voice to Parliament and executive government. Now, I'm strongly of the view that, of course, as Aboriginal leaders like Noel Pearson have said, is we want a place at the table in dealing with executive government. My only issue is that that should be done by the Parliament and not through the Constitution. And I think at the end of the day, I and Robert French probably agree on that.
And you've put forward in your book released this week, which I have a copy of, it says a proposed amendment as an alternative to what the Prime Minister released last July. You say there shall be an Aboriginal and Torres Strait Islander voice with such structure and functions as the Parliament deems necessary to facilitate consultation prior to the making of special laws with respect to Aboriginal and Torres Strait Islander peoples, and with such other functions as the Parliament determines. So explain it to our viewers, but from your very clear form of words, it's stating explicitly that it's the Parliament that's the ultimate arbiter, that it can't then be challenged in the High Court.
Sure. What I've tried to do is take three distinct steps, Kieran. First step, Aboriginal people have told us at Uluru there's only one way in which they want to be recognised in the Constitution. That is with a voice. And, as they said in the Referendum Council, a voice to Parliament. So I think that's non-negotiable. So when you look, secondly, at what a voice to Parliament might do by way of a constitutional function, particularly if you're trying to appeal to more conservative voters and to more conservative political parties, you acknowledge that the Constitution provides that the Commonwealth Parliament can make special laws with respect to the people of any particular race for whom it's deemed necessary to make special laws. Now, in the 21st century, that only applies to Aboriginal and Torres Strait Islander peoples. So the second proposition has to be, well, if you're going to have a voice, it's got to have a constitutional function in being consulted by Parliament before Parliament makes special laws that applies to them. The third part is then to say, once you've got the voice in the Constitution as what Noel Pearson very felicitously describes as a hook, once you've got that hook in the Constitution, then you can provide that, yes, the voice can do all sorts of other things which the Parliament determines it will do. So the Parliament can decide if they want the voice to be commenting on other laws, not just special laws. The Parliament can decide whether they want the voice commenting on ministers making policies. The Parliament can decide on whether they want the voice being able to make representations on decisions by public servants of administrative nature. And then if problems arise, as Justice French rightly said, then the Parliament can review that. So I think it's neat, it's clean, it's true to the Referendum Council report, and I think it's true to Uluru.
The form of words that the Prime Minister did choose last July, just to give our viewers a bit of a sense of history, it was only one of 18 proposals. There were 18 proposals, in fact, that were put to that committee back in 2018, but he chose one, and that was the one from Noel Pearson, and he's run with it.
Yes. From Noel Pearson, Megan Davis and Pat Anderson. Three very respected Aboriginal leaders, I really concede that. But let's face it, Kieran, that submission was put in 2 months late. And it was put in such a way that the Parliamentary Committee, chaired by Senator Patrick Dodson and Julian Leeser, and with members on that committee including Murrindili McCarthy and Linda Burney, who are now the Assistant Minister and Minister for Indigenous Affairs, they all said, look, this needs much more work on it. And they were dead right. It did need much more work. Now, to do the captain's pick, I can understand how the government thought, well, we've had 3 Liberal Prime Ministers in a row who have said no to this. We're freshly elected. We're going to sit down with the Indigenous leaders and we'll take them into our confidence and they'll take us into their confidence and we'll run with what their preferred leadership said. I can see how that made some sense at that time. But now we're at the pointy end of saying, well, now, how do we get a formula of words which is acceptable across the aisle in our Parliament and a formula of words which is dead certain? I've always said, Kieran, my mentor in this sort of exercise was the late Bob Ellicott. Bob Ellicott was the Attorney-General who successfully prosecuted 3 out of our 8 successful referendums in Australian history. And Bob always said, rule number 1, you've got to have absolute legal certainty. Why? So then the likes of Frank Brennan don't have to be appearing on national television talking about legal uncertainties. So the Prime Minister doesn't have to be at the press club quoting one judge over against another. You need to be able to put all that behind you so you can get on with the clean, decent, proper campaign of saying, come on, Australia, let's put a voice for Indigenous Australia into the Constitution. But at the moment, we're bogged down in these constitutional weeds.
Because you are a strong supporter of the voice, but you've just got your issues with the framing and the way it's been put together. And as you said, you said this week that the process has been dead wrong. And you also mentioned that of the 25 efforts that Labor's tried to change the Constitution through a referendum, 24 have failed. So how do they get that process back on track now?
Well, exactly. And with all respect to those who say, look, you don't have to worry about getting bipartisan support nowadays because young people only read Twitter and things like that, I don't think that washes. When it comes to amending the Australian Constitution, the Labor Party needs a bit of humility. Yes, they've tried 25 times and failed 24 times. To have voted in the successful Labor Party referendum, you have to be over 97 years of age. And it was about things like maternity allowances and child endowment, things which could be extended to all citizens. This is something which is quite distinctive. And in order to get there, we do need Mr Dutton and Mr Lisa to be solidly on board with whatever goes forward in terms of the proposal of words. And if we don't, we're going to have continuing division where, sadly, a referendum might not only be lost, but the campaign itself would cause division rather than unity in the community. And that's why I'm going in strong at the moment. I think now is the time for the humility to be learnt, mistakes to be admitted, and to say, right, let's get the formula of words right. Let's have absolute legal certainty so we can all get out there and then evangelise the cause of an Indigenous voice to Parliament, full stop, but with then provision that Parliament can provide that the voice can then do things with executive government subject to statute and not as a constitutional entitlement.
Because at the moment, just finally, at the moment, voters are out there that have to be deciding between High Court judges at the moment, saying, OK, we'll weigh up this one versus that one, because the opinions, it's basically, they're mixed right now.
Show me a punter in the street who wants to say, well, I'm not only keeping up on the present High Court, but yes, I've got French who said this, Callanan who said that. At opposite ends of the scale, we've got Hayne in the middle. We'll have a few others buying in. For God's sake, that's no way to amend the Australian Constitution. And it's no way to do our politics. And it puts them in a very invidious position. They are people of the highest integrity. And the irony is that, of course, what we've got is a series of the more progressive lawyers out there saying, oh, don't worry, this won't mean any change. Let me assure you of this, Kieran. If the amendment were carried, it'll be those progressive lawyers who'll be the first ones appearing before the High Court saying, aha, here's a constitutional entity, it's got a constitutional entitlement, you, the High Court, should now develop a novel jurisprudence. And that's why Callanan has rightly said, no matter what you think of a voice, yes or no, if the present provision was voted in, there would be a decade or more of litigation as that jurisprudence and jurisdiction was established. And we need to avoid that.
Father Frank Brennan, yeah, we do indeed. Thanks so much for your insights and the work that you've put into this, an Indigenous Voice to Parliament, considering a constitutional bridge, your book out this week. Thanks for your insights. Appreciate it.